oil sheen is moving into Kachermak Bay tonight. Residents in the village of Port Graham are trying to boom off what they can.
Right now, it is the current that's sweeping the finger-like patches of oil toward the Cook Inlet. Oil has now been spotted washing up on the Chugach Islands, but for the most part, the large globs of oil seem to be staying offshore.
On March 24, 1989, an oil tanker owned by the Exxon Corporation, now ExxonMobil, ran aground on Bligh Reef in Prince William Sound, Alaska. Approximately 11 million gallons of crude oil were discharged into the surrounding waters, causing one of the largest environmental disasters in US history. Marine insurance is a type of insurance coverage that provides protection against risks and losses associated with maritime activities, particularly the transportation of goods, cargo, and vessels.
Absolutely right. There is every indication, at least here in Valdez, that this cleanup has begun a new phase. The Department of Environmental Conservation reported today that some 3,000 beaches so far have been fouled by the oil spill. But for the past 2 days now, crews have begun an operation that just might help those beaches recover faster.
In the aftermath of the spill, Exxon faced substantial financial liabilities, including the costs of cleanup, environmental remediation, and compensation for economic and environmental damages. To protect against these potential losses, Exxon had obtained insurance coverage from various underwriters. The environmental damage was devastating. The financial impact was also massive. Exxon Valdez, the ship carrying the oil, was insured for $120 million, but the total cost of the disaster exceeded $3 billion. Policies included a primary liability policy and an umbrella access policy. By now, the public was outraged over the environmental disaster. Protesters with Save Earth banners and contraband were active, and the media spotlight itself was harming the company's reputation. Articles and editorials about the spill stirred the whole nation in a giant uproar, and the news went overseas soon after. Meanwhile, disagreements emerged between Exxon and its insurers over the extent of coverage and indemnification for the damages resulting from the oil spill. The insurers contended that certain policy exclusions and limitations applied, potentially limiting their liability and reducing the amount of coverage available to Exxon. One such key point of contention was the interpretation of the term occurrence in the insurance policies. Exxon argued that the oil spill should be considered a single occurrence, while the insurers claimed that it constituted multiple occurrences. The distinction was critical because the policy limits and deductibles varied depending on whether the spill was classified as one or multiple occurrences. Exxon maintained that the tanker's grounding and subsequent spillage were interconnected events that constituted a single occurrence. The company argued that the spill was a result of a single negligent act and should be treated as one incident for insurance purposes. In contrast, the insurers asserted that each discharge of oil from the tanker should be considered a separate occurrence, thereby reducing their liability under the policies. Another significant issue in the case was the application of pollution exclusions within the insurance policies. The insurers relied on these exclusions to argue that they were not obligated to cover damages resulting from pollution-related incidents such as the oil spill. Exxon challenged this interpretation, contending that the pollution exclusions should be narrowly construed and coverage should be provided for the environmental and economic consequences of the spill. Legal battles surrounding the insurance dispute spanned over several years and involved the multiple lawsuits and appeals. In 1994, the US District Court for the District of Alaska issued a ruling in favor of Exxon, finding that the oil spill constituted a single occurrence. The court held that the insurers were obligated to provide coverage up to the point. However, the case did not conclude with this ruling. The insurers pursued further appeals, and in 2001, the US Court of Appeals for the Ninth Circuit overturned the District Court's decision. The appellate court held that the oil spill should be classified as multiple occurrences based on the distinct releases of oil over a period of time. This ruling significantly limited the amount of coverage available to Exxon under the policies. Following years of litigation, the parties ultimately reached a settlement in 2009. Under the settlement agreement, Exxon agreed to pay $507.5 million to its insurers, and in return, the insurers released Exxon from any further claims related to the spill. Before this, marine insurance policies didn't always consider the full scope of the risk associated with oil tankers. After the disaster, there was a push for comprehensive policies that could adequately cover the cost of a catastrophic spill. The Exxon Valdez disaster exposed flaws in the marine insurance industry and led to calls for better regulation and oversight. This case underscores the importance of clear and precise policy language, judicial interpretation, as well as the careful consideration of exclusions and limitations in insurance contracts. Differing interpretations of key terms such as occurrence and pollution exclusions played a central role in determining the scope of coverage and liability in this case. While the Exxon Valdez insurance case is a stark reminder of the devastating consequences of environmental accidents, it also serves as a catalyst for improving insurance practices, stricter regulations, and heightened awareness of environmental risk in the corporate world.
National Oceanic and Atmospheric Administration, NOAA, Dr. William Evans announced Exxon has indeed cut the check, the money to go towards not only assessing environmental damage, but to restoring Prince William Sound to its original condition.
We are very pleased with this agreement. The $15 million does not represent a cap. It represents a floor, if you will. It is a down payment. We do not have the slightest idea of what the assessment is going to cost.